Okay, if we could resume the hearing, please. So just before the break, Dr. Dawson indicated that he wanted to come in. We were discussing the mole implications of the site. So Dr. Dawson.
Yes, thank you. There's two things related to mole, which I haven't managed to say yet. One is that essentially we've been told that this place is, in biodiversity terms, degraded, so it would be easy to upgrade it with some kind of developments which may be led by the owner in the western part of the site on the golf course. It's worth saying, I think, and reminding people that I waived this earlier. I'm joint author of this. It was prepared for the London Borough of Merton. It's entitled Nature Conservation in Merton. It's dated 1998, and it covers the whole map of Merton, and it identified the sites of importance, which are still there today. Nothing's changed since then in this area, except that most of the information that was used to put together this handbook, after extensive consultation, has been ignored by the London Borough of Merton in recent years, and particularly on this site. So it's a site of borough importance, of grade 1 borough importance. Was then, still is, hard to improve because it's good already. That's the first point to make, and that's about the character of the MOL. Let's not be deceived. It suits people to argue that this place is degraded. It isn't. It could be improved, but that's difficult, and it certainly can't be improved by adding grass tennis courts. The second point I'd like to make is that there's an unfortunate error in relation to this same topic in the WI3 text. WI3 text says, and I'll quote it, "This site is in an area identified as being deficient in access to nature. The council will require proposals to alleviate this deficiency in accordance with the green infrastructure policies." Now that's incorrect. The reason why it's incorrect, there is a map showing the areas of deficiency in access to nature in the Green Spaces report. And that shows the whole heritage park as a, and I quote here, sink excluded from area of deficiency analysis. So the whole area that we're talking about today, the character of which I've been describing, is excluded from the area of deficiency analysis. No reason is given for this exclusion. So the green and blue infrastructure, biodiversity and open space studies makes an unsupported decision here to exclude this entire area. In fact, there's access to nature close to all three entrances of the public park. So that led to an erroneous identification of deficiencies surrounding WI3, allowing a claim that WI3 might reduce a deficiency. As this area of deficiency is erroneous, there's no such deficiency to redress. In this regard, the policy is unsound. It's based upon a straightforward decision to exclude the area from an analysis with no reason given.
Thank you, Dr. Dawson. Ms. O'Donnell, you've got your hand up.
Thank you. Yes, just to respond to Dr. Dawson's point there on the area of deficiency identified. The green infrastructure study was carried out using a number of different methodologies, depending on which aspect of green infrastructure was being looked at. So in London, the London-wide methodology that is generally used by councils is the GIGGLE, or I will expand on that, Green Spaces Information for Greater London, which have a specific area of deficiency model. That is used both through marking access points on a GIS map, and also those access points were also checked through site visits by the consultants. I will make the point that there are some locations on the maps in the green infrastructure study that do say they are excluded, and that is simply a case of those are not publicly accessible sinks. So sites of importance for nature conservation. While yes, that part of the Wimbledon Park is identified as a sink, it is also identified as not being publicly accessible. So that is the whole point of the area of deficiency model, to identify areas that are not publicly accessible, so then councils can try and improve access to biodiversity. So those policies are set out in the London plan and also in Merton's development plan as well. So the whole reason why the site allocation refers to this is because the council is of the view that access should be improved to the nature conservation on that site. And currently, the access is only to the Wimbledon Park publicly and not to the golf course itself. So hopefully that provides some clarification.
It doesn't. There was absolutely no doubt that there is public access to nature at each main entrance to the public Wimbledon Park. I could give you chapter and verse now if you'd like. I actually developed the area of deficiency policies for London when I was working for the London Ecology Unit, and I know how they should be applied. Excluding this area on the grounds that it has no public access is to exclude it on the basis of erroneous grounds. There is access to an area identified as a BERA Grade 2 site of importance, very close to the Revelstoke Road entrance. There's access to Horseclose Wood, which is included, everybody agrees is included in a BERA Grade 1 site of importance, very close to the Wimbledon Park Road entrance. There's access to Aston Grove Wood, very close to the Home Park Road entrance. These were facts back when these sites were first published in the handbook, and it's still so today. This site has been excluded erroneously, and so the area of deficiency has been defined incorrectly. Rubbish in, rubbish out.
Okay, thanks. I've got your point on that, Dr. Dawson. I think that's something we'll reflect on, particularly when we come to look at the green infrastructure study in more depth, particularly at stage 2, but for flagging it in terms of particularly how it affects this allocation and the drafting there. Any response to that, Ms. Butler?
I'd just like to point out the policies map, which shows what the designations referred to in this local plan for sites of importance for nature conservation. Its policies map is OD2 of Merton's submission local plan, and the sites of importance for nature conservation are on page 7 of that document. It doesn't show land ownership, but it does reflect what Mr. Doyle pointed out about the location and access to those sites.
Okay, any further points on mole specifically before we move on to effectiveness of the policy? So Mr. Roche here.
Yes, thank you. Just very quickly, it was actually to do with your points I think you raised earlier about the de-designation of part of the MOL, and I think I heard correctly you said you might come back on site to visit, and simply just to endorse that, because I think that would be the best way forward. I think when you came last time, I don't think you went up to that part of the site. But just for clarification, the areas that are in there are the practice courts, which are fenced and are on terraces. There are a number of buildings at the northern end which support player facilities. There's also includes the Irangi Terrace, which is known better as Henman Hill, which actually is a man-made structure. It's above a service yard. Whilst it may look very beautiful, it is actually built form. It also includes areas above broadcast and media, which are green roofs, but we'll happily just walk you round at the appropriate moment, and we can decide. Well, you can decide yourselves on that best approach there.
Yeah, thanks, Mr. Roche. I mean, the appropriate time to do that will be as part of our either when we're preparing or sort of in the wings for the October hearings. Mr. Coombe.
Forgive a rather dumb question. I'm not familiar with these processes. I am familiar with planning inquiry processes. And as I understand it, there on the planning inquiry, the inspector, if he's going to inspect the site, would go along not only with the applicant, but with opponents. Is that proposed here, please?
We can do it, yes. I mean, there's different sorts of site visits we do. Most public, most local plan site visits, the inspector would do unaccompanied if it's publicly visible land. We did the pre-hearing site visit as what we called an access required site visit. So we were accompanied by the land. Well, it was actually an accompanied site visit because we were accompanied by the landowner and the council. But yeah, if interested parties did want to accompany us on the site visit, as long as it's okay with the landowner, then I'm sure that's something we could facilitate. I'm looking at Mr. Rush here.
I don't think that's a problem at all. No, that's absolutely fine. Just whenever you want. A bit busy at the moment, but at some point afterwards, yes.
Yeah. So again, you know, given the time of year it is, it'd be in the autumn probably when we do the next site visit. So, okay, and Ms. Roberts.
Thanks. It's just to emphasise the point about the plan policy in relation to metropolitan open land, saying one thing, and this, it just to emphasise that the allocation, that including the including that, it just doesn't sit right at all. It feels like there's a move towards encroaching on MOL. Removing some of the MOL is definitely proposed. And I just wanted to put that in the context of a very large number of what I would call threats to metropolitan open land around London, increasingly coming from commercial organisations, often sports organisations, and to, you know, emphasise really strongly that you know, the planning system needs to, you know, work to protect these sites. In many of these cases, we are ending up having to rely upon legal covenants to protect them rather than the planning system, and it's just really to emphasise that the planning system obviously is here to protect those sites and not to make it easier for development. Metropolitan open land, obviously, in particular, it's not, you know, it's not, the whole intention is to ensure that there is open land available there into the future, that it's permanently there and that it's not developed, and that you know, that we feel really strongly that this that, you know, this is becoming more and more of a problem in London, and that we need the system to kind of respond appropriately. Thanks.
Okay, Ms. Butler, final points, please, on metropolitan open land before we move on, please.
Just to say that as set out in the MPPF and London plan, it's the metropolitan open land should be reviewed with the local plan, and that's what we've done.
Okay, moving on to more general sort of effectiveness points and the deliverability of the policy. If I can invite Inspector Aston in to lead the questions on this next section, please.
Thank you, Inspector Fort. Okay, so in a few of the hearing statements, reference is made to a recent High Court judgment relating to the Holocaust Memorial proposal, and that's London Historic Parks and Gardens Trust v Minister of State for Housing and the North, 2022 EWHC 829. And on our reading, parallels have been drawn between the circumstances of the proposed site, of the proposed site in that case, and the We3 site, and we just want to explore that a little bit further. And I'd like to invite some general views, please, as to what the significance of that judgment is for Inspector Fort and mine examination of the effectiveness of this allocation, please. I think I'd invite Miss Butler first, if she has anything kind of general to say, And then perhaps Wimbledon Park Residents Association representative, please. Ms. Butler.
Yes, I think, Inspector, what you're drawing to is the issue of the covenant on part of the site. As we know, while covenants are not a planning matter, if they affect the deliverability of a site proposed in the local plan, it's something we must consider. We don't consider the merits or demerits of a covenant. We simply consider whether or not it would impede deliverability. So in that point, the existing covenant legally, whether it should or will be overturned or moved on from, legally it can be, and that's the point on deliverability. It's not for the local plan to say this must happen, but it's for the local plan to set out proposals for a site and recognise that if there is something such as land ownership or a covenant that would absolutely in all circumstances impede deliverability, that's recognised. So that's the test. It's not whether it definitely will happen, it's whether legally it could. And your considerations legally it could. And part of that has been consideration of the case up near Buckingham Palace, I think, about the war memorial. Now, I'm not a lawyer, but I understand that the difference on that case, I'm advised, is that it wasn't actually a covenant. So while there are parallels potentially with assessing whether a legal arrangement could impede the deliverability of a particular form of development, I understand that it wasn't exactly a covenant in the other case, and that therefore there were slightly different legal mechanisms involved.
Okay, well, thank you.
Yeah, it was an act of parliament in that case. But setting that aside, I think so. Just to help Inspector Aston and I. So your view is because it's theoretically possible to extinguish the covenant, if that's the correct term, then it shouldn't be seen as an impediment to the deliverability of what the allocation is talking about.
Yes, I think it's important to note some of the details of the covenant, which refers to openness and other matters. So if you like, it kicks in when openness might be challenged, and we're proposing an allocation that includes metropolitan open land. So from a planning perspective, we're also mindful of openness. So the question is the allocation going to be completely impeded from being allocated by the presence of a covenant, of this particular covenant? And in our view, it's not. In our view, that can continue with the allocation, it can be made deliverable during the lifetime, the 15-year lifetime of the local plan. And that's another important point. And that it doesn't sufficiently impede deliverability as to merit its removal from the local plan.
Ms. Butler, if I could just come in on the end of, that, just to add a kind of, just a note that, noting the Wimbledon Park Business Association view that Merton Council have got a public law duty to enforce the covenants. And then there's also some references in the representation from Ms. Roberts, the CPRE, about the Public Health Act 1875. Does the council wish to make any comments on those two particular points, please?
Not really. I just draw attention again to the, it gets into the exact wording of what the covenant says, the exact wording of what the allocation says. Can open land uses be developed and comply with the covenant? It'll be a question of what would come forward at what time. And I come back to the point I've made to say we believe that the site is deliverable in the presence of this covenant.
Mr. Coombe.
Thank you, Inspectors. Before I come on to the legal points, could I just make a general point that it was really very surprising that Merton did not recognise the existence of these covenants, which they had imposed as a public law matter in 1993. There was no reference at all in this planning process, this local plan process, to that. I'm not surprised the All England didn't raise it, but as a rather fruity speaking friend of mine puts it, does this pass the smell test if it's not mentioned? Then I'd like to come on to the legal points, which are less fruity. Firstly, this is, Ms. Butler, Merton have dismissed this issue as it's not a planning matter. That's a narrow view on material considerations in planning applications, but we're not dealing with a planning application. We're dealing with a local plan, and NPP 35 tells us that it has to be effective and deliverable. And Merton know very well that they hold the park, which has the benefit of these covenants, as a public trustee for the public. They are not free to release the covenants. So as a result of that lack of freedom, these are just as binding as the private act of parliament. In fact, it was discussed in the Holocaust memorial case that someone could apply for a fresh private act of parliament, and you always could. That isn't the point here. The point is that Merton have led the public to believe that these covenants are in place, and in the language of a recent council statement, will be respected, whatever that means. I'd like to make a second point about that. Because the covenants didn't simply create private rights, and it's accepted that private rights are not a planning matter, but that they created public rights, then there's a whole raft of cases that, and I can take you through them if you wish, but there's a whole raft of cases that support that public matters like that are relevant to the deliverability of this plan. Take the rather fruity test and the lack of engagement with the covenants together. We and all the residents' associations which have the benefit of Merton's obligations are really rather surprised that they're pressing for this to be ignored. I can come back to detail if you would like. Thanks.
So we talked this morning about the distinction between the two broad elements of the WI3 allocation. So whether the existing operation is ongoing, and then the golf club, I'll just crudely refer to it as that for now. And we talked about whether the policy was clear, given that there's that chalk and cheese. Now, if there was some alterations to the policy, if there was some nuance there, bearing in mind what the intent of the covenants is that something that could help, Mr. Coombe, do you think?
I've already put in our written submissions that the covenants are intended to preserve the openness of the land and to preserve its use for recreational and sporting purposes. In fact, it's leisure, recreation, and open space, not sport. It's leisure, recreation, and open space, which is also referenced in the NPPF. That is leisure, recreation, and open space enjoyable by the people who are the surrounding community, not the opportunity to watch professional tennis players. Lovely though that is, and perfectly charming on the site on the west of Church Road as that is. The allocation of this site, if it were to adopt the same language of the covenants, and if it were to be a separate site allocation unique to the land to the east of Church Road, because as you've heard already, we just don't see the chalk and cheese comparison working here. If the land on the east side of Church Road were allocated for open space, recreation and leisure, then its purpose would suit the covenants.
Mr. Roche, yeah.
Thank you. I'll come back in general sense, but we can discuss any detail from the EB. Just to start with, it is not unusual at all to have covenants, indeed third-party land ownerships within site allocations and planning policy. This happens all the time. I suspect the number of sites that have been before you under consideration have exactly the same issues. They will have different terms accepted, but they will have similar issues. And obviously it is a matter of public law. And there is a process in place for changes in covenants under public law. I think just in terms of the Holocaust, again, I, like Ms. Butler, I'm not a lawyer, but my understanding of the judgment was, firstly and foremost, that was a planning application, not a site allocation, which is an important distinction between the two. It was an Act of Parliament, which is a breach, but it rested significantly on the matter of timescales and deliverability in terms of timescales. One of the pressing reasons behind the Holocaust Memorial was to have it in place and developed by the time the last surviving member of the Holocaust was still alive. That was an important consideration the inspector in that case drew. However, he didn't apply the challenge of getting around an Act of Parliament to that timescale deliverability, and it wasn't applied correctly in their assessment of alternative sites. It wasn't taken into account. So whilst an Act of Parliament, which did on face value challenge whether or not that development go ahead, it was down to the timescale for that which may be removed, and it was the impact on that and their consideration of alternatives in the timescale that they had attributed significant weight in the planning decision to. So it was a different, very unique consideration in terms of that. Now, again, it is quite a long judgment and it is a legal judgment, but that was our reading of that, and that's the advice that we've had. So there is a clear distinction between the two in the way that the inspector did. There was no comment in the judgment on the other considerations the inspector had made in the merits of the scheme. It was down principally to the fact he hadn't taken into account properly the timing it would take to develop that in light of his importance that he placed on that.
Mr. Steiner.
Can I just pick up one part of the covenant, which is the public lakeside walk? In the Space to Thrive report, it says access, use of parks and green spaces, enhance physical health, etc., etc. The need green spaces, the quality matters, and various other things which is in our submission. But well-being and nature are very important. And one of the troubling things about Wimbledon Park is the lack of decent walks. They're all poor. And one of the big activities is walking, over 60%. So the covenant, which is this on the lake, provides a great basis to provide a walk around the lake with the agreement of the three owners, 4.75 hectares, bird hides, resting places, and enjoyment. So I'll just make that point in passing.
Thank you, Mr. Coombe.
I would like to debate some of the legal points if the All England would like to put their lawyer up for this, but he's not here, unfortunately. What I would say was that timing of the All England's application is, according to their timetable, absolutely critical and has the same concept of deliverability, if you like. That's not my main point. My main point is that the restriction which the council placed is a public law matter, not a private law matter. The council have promised the public it will be in place and are not free to release it. And as a result, it cannot be assumed that the covenant can be ignored. Mr. Rolfe is absolutely right. There are masses of sites burdened by all sorts of private restrictive covenants. This is not one of those.
Thank you, Mr. Coombe. I think just a point I would make on this is obviously as inspectors, both in Section 78 work and examinations, we come across judgments all the time That will obviously be Inspector Fort and I will reflect on that further as to what we've heard. Is there anything else that anybody wanted to add in relation to these covenants? Mr. Coombe, I'm just saying you wanted to talk about some of the detail. Obviously, no discussion between lawyers because we've got two inspectors and a hearing session. So any questions to us, please. But if you did want to kind of just drill down a little bit into that, the purpose of the covenants and your view, that would be very helpful. I think you mentioned not to be used other than for leisure, recreation, or as open space. And you mentioned this issue about openness, and I'd probably put it to you. Do you have any comments on whether, if you had a scheme or an allocation, I should say, not a scheme, proposal, whatever way you want to couch it, that did preserve openness, then would that still be in breach of that covenant? So just some of your views around that topic, please, Mr. Coombe.
Thank you, Inspector Aston. Yes, I'd be happy to do that. If you've seen the Wimbledon Park Residents Association's second submission, submitted, find the date, May the 18th, you'll see a lot more detail about this point. We touched on it in the first of our submissions last September, but I can just summarize some of the aspects here. One of the most important points, I think it's necessary to go back to 1993 when the All England bought the freehold of the golf club. Merton had put it up for sale. A great number of local residents, and two of them are sitting alongside me now, objected to the sale. Merton Council promised to not only to uphold the metropolitan open land, the conservation area, the sink and the archaeology priority zone statuses of this land, but they promised formally, hearing objections and really strong views from the Wimbledon Park Residents Association, the Wimbledon Society, the Wimbledon House Residents Association, and a great many other local residents, that the land should never be developed. And as a result, and this is recorded in council minutes, which are available in the library of this very building, as a result, the commitment by the leader of the council then was given to the local residents that it would never be built. And the text of the restrictive covenant was inserted in the sales particulars when the site was put out for open market sale. The buyers therefore bought clearly with an open eye to what they could and couldn't do with the land. And in fact, the assurances given when they announced the selected buyer in September 1993 confirmed that the land would not be developed. Those promises from Merton Council to the local residents are enforceable. We've been advised by QC to that effect, and that's confirmed our own researchers. Coming on to what the text of the covenants, they allow leisure, recreation, and open space use, and some buildings ancillary to those uses. A case involved Oxford United Football Ground proposal in Cowley near Oxford, in which a restrictive covenant against anything other than recreational use was sought to be set aside. And there the judge said, and I've cited it in the written submission, that watching professional footballers play football is not a recreational use. And I just invite you to substitute tennis for football in that case. The covenant does not prevent anything at all. It doesn't pickle the golf course in Aspic at all. It allows compliant development. If the covenant is being pushed to its very boundaries, the local residents need to be engaged to authorize Merton to release it. But if a proposal comes forward for some leisure, recreation, or open space use, that would be appropriate. We've heard earlier from Dr. Dawson about the biodiversity and the hazards to biodiversity of excavation for tennis courts. I think it's fair to say that the covenant does not, I don't think people really thought about biodiversity in 1993 somehow, but maybe they did. But the covenant doesn't actually stop that sort of excavation and open tennis courts, but it is required to be kept open, not built upon, not a very large stadium, not a 30,000 square feet industrial unit, not 10 other buildings, such as, I'll just give an example of the planning application. So yes, some open space, some parkland, some football, some public park spaces, such as is part of the current park, would be compliant with the covenant. I think I better stop there, but I'd be happy to take further questions and elaborate.
No, thank you, Mr. Coombe. Sorry, Inspector Ford, did you want to come in there?
No, I was just going to thank Mr. Coombe. If you want to carry on, please, Inspector Aston.
Yeah, I was just going to finally, I was going to invite Mr. Rocher if he had anything finally wanted to say before wrapping up with Ms. Butler. What I would say, Mr. Coombe, I'm not entirely sure kind of how much detail at this stage you would want to add. You know, clearly we're aware of the and understand what obviously the argument's being put forward, and I think Inspector Fort and I will need to take some time to reflect on that. So I will ask Mr. Rocher if he wants to come back on any of those before hearing from Ms. Butler. If there are any new points, Mr. Coombe, in that, then feel free to turn your plate up and we will take your comments. Mr. Rocher, please.
Thank you. I won't go into detail. I mean, it is a legal matter, particularly, but I will say that I think there is, in fairness, there are a difference of opinion on the interpretation of the covenant and what it means and how it is applied. We won't go into detail about it here, but there is a difference of opinion on those points. I would reiterate, again, this is not uncommon in the development industry. It is a site allocation we're talking about here. It is arguable that a form of development under the allocation as currently drafted could come forward, which wouldn't necessarily constitute a breach. So, I mean, that is all I think we can say on the matter, but as I say, it's emphasised it's a public law matter. It is not uncommon. And there is a difference of opinion between parties on interpretation. I think we'll leave it at that. But we are confident in the deliverability of the site because that is the test. The deliverability of the policy as currently written at the moment, and obviously we have put a planning application in. I know that is not under consideration here, but we wouldn't have done so if we did not believe it to be deliverable.
Okay, thank you. Unless there was anything else from Mr. Coombe, I just invite Ms. Butler to have the final say on this particular question. And essentially, Ms. Butler, in view of what we've heard from Mr. Coombe, in view of those covenants, how effective is the allocation? If you just want to have the final say, please.
We believe the allocation is effective. There's clearly a variety of legal opinions, and I think we draw your attention actually to the Wimbledon Park Residents Association hearing statement on page 3, which neatly summarises the covenant very nicely. I'd also like to mention that Mr. Steiner brought up access to the lake and walking around the lake, and just to say that that also came out strongly as a desire from respondents to the council's work in 2016, which informed the 2018 Wimbledon Park Master Plan.
Okay, thank you.
Mr. Coombe.
Mr. Coombe.
I'm sorry, you could do without a legal topic in the hot afternoon. Forgive me. Can I just mention a couple of points? Mr. Rocher is quite right that private law covenants are not uncommon in planning matters, not uncommon in property matters. Many of us wouldn't have made a living out of this if they were. But there we go. What is uncommon is that this is a very specific and particular promise by a public authority to its public. And I think that is wholly exceptional. I've never come across this sort of situation before in 45 years of experience of this business. Can I also mention that, and my colleague, Mr. Simpson, from the Wimbledon Park Residents Association, received a letter from Mr. Hewitt, the chairman of the All England, when this covenant issue was raised with the All England in July last year. I'll paraphrase, read part of it. As to the assurances made in 1993, I'm sure you can appreciate that the requirements of the club and the community have developed in the resulting 28 years, and the AELTC has needed to work to ensure the champions remain a preeminent tennis tournament. It's been our stated aim for many years that purchasing the golf course, and especially the freehold, was done with the intention of moving our qualifying event on site. That's not true. They didn't buy the freehold to move the qualifying event on site. I think you have here the parties to a covenant. One of them is a public authority with massive public duties. The other one is a private developer trying to make money out of it. We've all acted for each of them. We know exactly where they stand, but this is a public promise that Merton must adhere to.
Okay, Mr. King. So yeah, that message is received. That there might be a material difference in your view in terms of this covenant, because there's that public law, potential public law aspect there, and that's clear in your hearing statement. As Inspector Aston says, it's something that we'll have to take away and reflect on. And we've heard all those points. And we've heard the council's view on that. I don't think there's any further we can go this afternoon on that particular point. Now, in terms of the allocation at this stage, and I'm mindful that we're going to receive some further work prior to stage 2. So Inspector Aston and I don't have any further questions at this stage. And we're happy to pick this up again in October. But before we conclude the session, is there anything anybody else wants to say before we wrap up? Okay, in that there's nobody wanting to come in there, so we'll come back to discussions on aspects of this in October, as I said. Thank you all for your contributions today and the helpful remarks people have made and the insights that we've received throughout the day. It's been a useful discussion. So all I've got to say now is that we'll close the session on this matter, take a short adjournment for about 10 minutes, then we'll come back and do the general closing for the stage 1 hearings. Okay, thank you.
Thank you everyone for your participation.
Yeah, so just for the benefit of people here, the closing session is it's something between us and the council. The inspectors make about this stage 1 of the hearing. So we just make closing remarks about what the procedure is from here on in. We invite the council to make any closing remarks they may have, but that's it really. There's no substantive discussion of any of the actual matters that we've discussed in the last couple of weeks. Okay.